Eric, Matt, I think we'll go ahead and get started. We'll try to keep this to a tight 30 minutes, let everybody roll whenever they need to. Um, I'll plan to stick around after 5 o'clock Eastern so that if there's anyone who has a particular special situation or a question they want to ask kind of off the record, we can kind of talk about that offline. But otherwise, our goal is to have a really good session. We're really grateful for Matt and Gary in joining us from Ross Law. But the idea here is that we'll take the next 25 minutes or so and walk through the key points of kind of the end of year fund health and performance review. Before we get going, why don't we do some brief introductions? So my name is Nate Snow. I am a partner and a co-founder at Graph Advisors. Graph Advisors is a small services firm. We work with venture capital clients to handle everything besides investing and fundraising so that our GP clients can focus on what they do best: sourcing deals, winning allocation, raising funds from their LPs, and supporting their portfolio companies towards those kind of big wins on the board. At Graph Advisors, we spend a lot of time blocking and tackling and building systems that create operational excellence for enduring firms. We kind of view things that at the end of the day, a venture fund is about moving money from LPs to the fund, from the fund to portfolio companies, from portfolio companies back to the fund upon an exit, and then from the fund back to those LPs. And then you do it all again for Fund 2 and Fund 3. But to move money, you gotta move paper, and to move paper, you got to get people aligned. So really excited to be here, and thank you all so much for being here. I'll pass it over to my partner Eric for a brief intro.
Thanks, Nate. Thanks everyone for being here. It's good to get everything in order as you go into the end of the year. As Nate mentioned, we're Graph Advisors, where we provide fractional CFO services for VC firms. With that, I'll turn it over to Matt for a brief intro, and we will dig in.
Thank you, Eric. Hi, I'm Matt Winkle. I'm counsel at Ross Law Group. We are a corporate and securities law boutique in Midtown Manhattan. We focus on public and private securities offerings, and a lot of fund work. My area of the practice focuses on forming and capital raising and everything else involved with venture capital funds, SPVs, and venture capital investments. We also do a little bit of hedge fund, PE, and real estate fund work. And as part of that, I also head up our regulatory practice, which involves all of the fund Form D, Blue Sky, and Form ADV filings that we'll be discussing here. So this is a great opportunity to get everybody prepared and ready for all the upcoming deadlines in early 2025.
Great. Well, we got a good team assembled. We're excited for our time together. In terms of what we'll do, we've checked off welcome and introductions already. We're going to spend some time on the why of an end-of-year health and performance review, the what of an end-of-year health and performance review, and then we'll dig in on some legal, some compliance, and some Form ADV upcoming things, and then we'll save some time for Q&A at the end. So really, like, why does this matter? And then what is it? How do we take some steps now to make the most of a performance review to prepare us for the year ahead? Before we jump in, though, quick disclaimer. Matt, I think this one's you in terms of attorney-client relationship. You want to give a quick voiceover on it?
Absolutely. I do see some RLG clients in here, so thank you all for showing up. But in general, this presentation is only for informational purposes and is not any legal advertising or legal advice, and there's no attorney-client relationship created by this presentation, and nothing in here should be viewed as specific legal advice.
Excellent. All right. With all the preliminaries out of the way, let's jump in. So the why of a health and performance review. First up is time. This is a really great time of year to conduct a health and performance review because you might have a little bit more time on your plate. Your LPs have partnered with you to do one thing, and that is to multiply and return their capital to them. And that means that during the bulk of the year, you're out winning investments, supporting those investments, working in partnership with your portfolio companies to achieve an exit, and time is in really limited supply. At this time of year, things slow down a little bit. Everyone's kind of tired. Everyone, not as many meetings are taking place. So you have a really good time right now to step back, to reflect, and to use this time wisely to do some of the thinking work, the mental work, the intellectual work that you don't always get to in the heat and the intensity of the rest of the year. Also, this is a time-saving effort. Time that you spend now is time that you won't have to spend in Q1 during the middle of an audit, during the middle of tax season, during the middle of the Form 8 EV filing. You'll be able to do a lot of that housekeeping and cleanup now to save you time later. And we know in our industry, in any industry, time is money. Taking some time now to review the performance of your year, to review the health of your fund is going to save you costs. You might find a mistake that you can correct now. It's easier to correct it now than it is to correct it after the fact. You might find a problem that you need to get ahead of as you head into the audit season. So taking the time now to review how your year went is a great way for you to save time for next year, which is earning you money next year, and also save money so that you can better use it on things that are going to generate alpha for your fund. So that's the why, time and money. Not a big surprise, I'm sure. In terms of the what, our recommendation is that you always start with a summary paragraph. This is a very quick way for you to take everything that happened this year and distill it into one paragraph. And you'd be able to answer, what is it? How did my year go in one paragraph? This might actually be the introduction paragraph of your LP annual letter, where you're summarizing the year. You're able to communicate both the tone, the sentiment, the vibe of the year, but also some of the key milestones, the key wins, and or recognize where there might have been some setbacks or some key learnings that you've had. So if you start with that summary paragraph, you're kind of thinking, this is how the year went, and then it can guide you out. You'll be able to identify, all right, what were those kind of Q1 things that lined up with this, those Q2 activities that lined up with this, what happened in Q3, what happened in Q4, but you start with that really clear kind of North Star summary. This is how the year went quantitatively, and this is how the year went qualitatively. If you start there, it gives you a lot of organizational muscle to then take on some of the next steps. The next piece of it's pretty technical, which is taking some time to review your company updates, your portfolio updates, and be prepared for evaluation exercise that'll happen in Q1. So this is, have you heard from all of your portfolio companies in the second half of 2024? Do you have updated financial information from those portfolio companies? Do you know for a fact that they're still active? For those that are in the process of winding down, where they notified you in August, hey, it didn't work, and we're taking steps to dissolve, do you have an update? Have they filed their certificate of dissolution with the state of Delaware, for example? All of this work and compiling these company updates is what you're going to use with your auditors to justify the valuations, the FMVs you're holding your portfolio at. And so if you can take some time to organize what's the mark I'm holding my company, Acme Widget Company at, and how am I going to justify that based on the information I have from the company? And is that justification going to hold up under the scrutiny of an auditor? Big amount of work here that'll save you a lot of pain and suffering in Q1. If you don't have to do this in response to auditor questions, you have it all ready to go and you can just share it. Next up is kind of portfolio model and pacing. You think about all the deal activity that you've done this year. You think about your cash balance. You think about future capital calls, the percentage of your fund that has been called versus the percentage of your fund that has not been called, reserve ratio, recycling. And you think, you're running all of those numbers, revisiting all of those numbers, and you're saying, all right, how many deals did I do this year? And if I keep this pace, when is my fund going to run out of investable capital? And is that on the schedule that I told my LPs when I raised this fund initially? So taking a look and stepping back and thinking about, all right, is the number of deals and the ticket sizes, are those in line with what I expected? Do I need to make some adjustments? And how do I get ahead of any adjustments that I need to make? Next up, we have kind of deal review and fund admin coordination. This is just kind of checking in with your key partners, particularly around your fund administrator. Your fund administrator is going to be a key linchpin in how you approach your annual audit. working with the audit firm, working with the tax firm, ensuring that any of your LPs who might have had a transfer, they transferred from a trust to another trust, or from one affiliated entity to another, that you've updated your fund administrator with all that tax information. You've been able to identify and are prepared for those tax and audit questions. Also, this is a chance to make sure that your fund administrator has all of the deal documents that you've invested on. So if it's deals that you've signed, that you didn't just send them the draft docs, they have the fully executed and countersigned documents for both you and the portfolio company. If it's a subsequent financing round where you didn't invest as a purchaser, but your mark has changed, the FMV has changed, that you've shared those documents as well. So every number in a financial, do you have the paper that supports that number? And this is a chance for you to get in and look specifically and make sure that you and your fund administrator are on the same page when it comes to presenting a unified front for your audit and tax work in Q1. Next up, we kind of just vendor check-ins. Vendor check-ins is just a way for us to, talk with the Ross Law Groups of the world, your tax firm, your audit firm. If you haven't done any Q4 field work for your auditor, talk like, hey, am I still on the schedule for you to audit my fund? Reminder, our LPA says that we need to deliver audited financials, by 120 days, April 30. How do we make sure that we're on schedule to do that? So who are those key who are those key service providers, those key vendors that you need to check in with? For your management company, do you have the expenses that have accrued, like that, the invoices, so that you can document those expenses in your management company financials, which would help bring down your net income of your LLC, the management company, and further reduce kind of the tax burden that you might have at the LLC level, either if it's a partnership LLC or if it's treated as a disregarded entity if you're the sole member. So there's a lot of work here to do. Have my vendors been sending me their invoices? Have those invoices been logged in our records? And then on the fund side, are my attorneys, are my accountants, are my auditors, are my tax professionals, are they ready to go to meet the deadlines that we have in the fund overall? And then the next one, I think we'll kind of take a quick pause here and turn it over to Matt to hear a little bit on the legal side. Matt, as you think about working with your clients at the end of the year, are there any kind of general housekeeping or closeout steps that you would recommend your clients or anyone take from the legal side, understanding this isn't legal advice?
Yeah, absolutely. I think a lot of what you talked about in terms of just making sure that you've got everything papered up with your portfolio companies, fully executed and recorded, applies to your legal documentation as well. And now the things that I'll be talking specifically with this slide don't necessarily need to be done at year end, but they're really good to take care of just to make sure you get started off, with the year on the right foot. And in general, just doing a general LPA review and housekeeping. It may sound simple, but making sure that your LPA is fully executed. Has the GP signed? Is it in a PDF copy? Do your service providers have it? A lot of times we don't necessarily, receive those copies of those documents from some clients. And then later down the road, when you need to refer back to it, or an investor is asking for it for diligence purposes, all of a sudden everybody's looking around for the DocuSign link. So it's just good to have and make sure that the fully executed copies in the right hands. Are all the subscription agreements from your investors fully executed? But not only fully executed, are they fully filled out? Are the required accredited investor representations filled out? Are the required AML and KYC elements of the subscription agreement fully filled out? Have you, as a GP, countersigned all the subscription agreements? Just making sure that you have all those documents fully filled out and countersigned and organized. And then also, do you have an up-to-date schedule of LPs? This will help in a lot of regards. That that'll be speaking out in the next couple of slides with Form D and Form ADV, but also most LPAs allow investors to inspect the schedule of LPs. So you don't want to be caught flat-footed if you get such requests. If someone wants to kind of understand the composition of the investor group and all that. So just make sure that you're keeping that schedule of LPs or members up to date, and that you have that organized in your files. Now we're moving on to the legal and compliance timelines. If you're an RLG client, you've been receiving a bunch of emails from us in the last quarter of the year to make sure that we're ready for these different timelines. But I'll start specifically with the Form D, because sometimes this falls by the wayside. Have the Form Ds for your fund been filed on time? And this is usually within 15 days of the first LP close. But a previously amended Form D may need to be amended. And that's either in the case of greater than 5% increase in the offering amount since the initial filing, or if you've raised a fund and the offering is still ongoing for longer than a year, then you'll need to amend that filing by the 1 year anniversary, or if material information about the fund or your SPV has changed, among some certain other things. And then also, we need to be thinking about the states which your investors reside in. So have all the necessary state blue sky notices been filed? Or are there any state blue sky notices that are set to expire in the coming year for one of your offerings? And with the blue sky notices, the deadline is the same as the Form D. It will be within 15 days of the date that the first investor in that state signs their subscription agreement. It's good to be aware of that, because while many states do not have late fees for blue sky filings, there are some that do, and they're quite onerous. So just making sure that you're on top of that and you understand what the deadlines are, which states you need to file in, and also to be clear that once you have filed a blue sky notice for one investor in a state with respect to an offering, whether a fund or an SPV, and if you onboard another investor for that state, you do not need to file an additional blue sky notice. And now we'll start talking about Form ADV. So the annual Form ADV amendment filing is due within 90 days of the close of each fiscal year. This year, it does fall on March 31st. Some years when it's a weekend, it's a little earlier. And it's good to just start preparing all of this information that Nate has discussed, that I just discussed about the LPA, the schedule of partners, because it'll be really helpful once you go to your counsel or you yourself begin to start preparing the Form ADV draft. But before we even get into the drafting process, it's important to know if the annual renewal fee and processing fee has been uploaded to your FINRA account. If you are a state ERA as a VC fund advisor, it will be your state's fee. And there are many states that are very hawkish about this, specifically California, Massachusetts, Delaware, where if your renewal fee is not posted to your FINRA account prior to year end, they will deregister you as an ERA. If you are an SEC filing ERA, your processing fee will be due at the time that you file. Now digging into the actual meat of what the Form ADV filing will encompass. So it will require you to report every fund and SPV that you advise up to 12/31 of the previous year. So is your list of funds and SPVs that you advise up to date? Do you have all of the relevant information that you will need about each fund or SPV to report on Section 7B1 or Section 7B2 of the Form ADV. Section 7B1 is for funds or SPVs that are primarily advised by you. And Section 7B2 is for funds or SPVs that you sub-advise. So if you've got SPVs through AngelList or Saks, some of the other platforms like Allocations or Sidecar don't act as primary advisors. So if you're using one of those platforms, the reporting procedure may be different than what you're used to with AngelList. So it'll be really important to make sure that you have all of the necessary information if you've used one of these other emerging platforms. Are the ownership percentages current for both your funds, but also for the advisor? So for the fund, every year you need to report the percentage ownership of that the GP has in any fund or SPV, the percentage ownership of the fund that's owned by fund of funds or non-US investors. So it's good. It's really important to make sure that you have the ownership composition of your funds or SPVs up to date. But also at the same time too, Schedule A of the Form ADV is a very important document. It reports to the state, to FINRA, to SEC, the ownership composition of the advisor entity. And that needs to be updated if, say, one of the partners in your management firm has departed, or you've added a new partner that either has control or owns more than 25% or more than 25% of the management entity. Or if maybe you've shifted around ownership of your entity and you, instead of being a personal owner of your management entity, you've transferred that to an LLC or a trust. That'll need to be reported as an indirect owner on Schedule B. So if there's been any shift in ownership percentage at either the fund or the management level, it'll be good to make sure you have that prepared to go into the drafting process. Also, it happens all the time. Has the principal place of business changed? Especially if you have under 100 million in assets and a VC fund advisor, because principal place of business is what dictates which state you are filing your notice filing via the Form ADV to. So if that's changed over the course of the year, you'll need to make sure that you're reporting to the right state when you make your Form ADV amendment filing. And then if you're keeping track of your AUM, this ties back into what Nate was saying before about marking FMVs, making sure that all that is up to date. Because if your AUM is approaching 100 million, you're going to need to make preparations to transfer from being a state ERA to an SEC reporting ERA and make the requisite Form ADV filing. Now we'll get into a fun and somewhat convoluted discussion about 2024 regulatory changes. If you joined us last year, there was quite a bit of discussion about the SEC's private fund advisor rules that were adopted in August of 2023. And everybody spent a good portion of 2023 and part of 2024 gearing up for and being prepared for the changes, because they did put a lot of extra burdens on advisors to private funds, including ERAs. So there was a healthy discussion about that last year. But in June of 2024, the Fifth Circuit vacated the rules, which would have been fully implemented by early 2025. And since the SEC elected not to challenge this ruling by the Fifth Circuit, those rules that we were all preparing and worrying about and getting prepared to comply with will not go into effect. But some of the rules, even though they aren't in effect, they did create some suggestions for just, good practices to keep in mind in advising your funds. And I think I just want to highlight a couple here. Just being mindful of your expense allocation methods, especially if you are an advisor to both SPVs and you have a main fund, or if you have multiple SPVs that you manage, and just specifically looking out for any kind of non-pro rata allocation of expenses among your different fund entities, among your different SPV entities, and also charging any of your management entities regulatory expenses to your investors, either at the fund level or the SPV level. Some fund documents allow this. It is not against the investment advisor rules, but more and more it's something that we see with our clients gets major pushback from investors, and is just something that usually isn't a good look. And then here's really the important one, I think, and can definitely get lost. Making sure that you are tracking and organizing your side letters for two reasons: just to make sure you know what obligations you have to each individual investor or group that you have made a side letter with, making sure you understand who has most favored nation rights, make sure you understand the thresholds for each investor that you have a side letter with, where an FMN is triggered. And also, a lot of FMN clauses require reporting of the similar terms or the more favorable terms to holders of the FMN by the final closing date of the fund. So it's good to be mindful of the deadlines that you have with respect to these side letter obligations. So end of year is a great time to just make sure you have all those ducks in a row. And now here we'll get into the Corporate Transparency Act, which is another item where there has been a lot of scurrying around this year, a lot of effort to understand, a lot of questions. I'm sure you've all gotten emails from Ross Law Group, from your registered agents, from any platform that you deal with that manages your fund or SPVs about the Corporate Transparency Act.
As you do it, we should just do the abbreviated version just for sake of time. But it sounds like
absolutely
we're in limbo. Yeah,
it is in limbo. The important thing is that there is a reporting deadline for reporting companies on 12/31 that is currently subject to a nationwide injunction, but as we speak this week, the appeal from the DOJ is going to be entertained by the Fifth Circuit, and it is unclear whether the injunction will be lifted, whether the Corporate Transparency Act is just going to go away, and also unclear how FinCEN will adjust to any delays in the deadline, or if the injunction is lifted prior to the deadline, what will happen. So anybody that has an obligation to file a BOI report with FinCEN should just needs to be prepared, and unfortunately paying attention to updates as they occur over the holiday season, because on February 27th, there could be a mad scramble to meet the 12/31 deadline. Nate, can I give like 2 seconds on the relevant exemptions? Just it is an important point. And
yeah. Let's do 2 seconds on that, and then we can transition.
Okay, so most people on here, if they advise VC funds, their management entity is exempt from the BOI rules, but they have to file a Form ADV claiming a venture capital fund advisor exemption, either with the state or with the SEC. And then any fund or SPV that they advise is also exempt under the pooled investment vehicle exemption, provided that those entities are currently reported on your Form ADV or on a Form ADV annual amendment. It is important to note that if you have any secondary investments in an SPV, that you will not be eligible for the VC fund advisor exemption because of the 80% rule for VC funds. So it's just good to, if you have secondary investments, it's good to check that. Good to check with your counsel to see if you are eligible for these relevant exemptions. Great.
Excellent. Matt, thanks so much for the overview. Guys, and everyone who's been able to join us, thank you so much. I'd love to hang out here and take any questions that people might have. If you want to drop something into chat or you want to come off mute, we'd love to, we have time to hang out, but of course, with the holidays, end of year, you might want to go put some of these suggestions into action right now and jump off and start getting some of the house cleaning items in order. So again, thank you all so much. You're welcome to hop here, or if you'd like to come off mute or put a question in chat, we can do our best to take it on. Thank you. Yeah, looks like yeah, go ahead.
Hi, everyone. I just wanted to find out if there's any disadvantage if you've already filed for the Corporate Transparency Act.
No disadvantage. For many of our clients, we've already supported them in filing. We're still paying attention just to understand what was happening, but no disadvantage if you've already taken the steps to file. The one advantage might be you don't have to pay attention to press releases from the Fifth Circuit over the next couple of days. Otherwise, no disadvantage.
Yeah, just to jump on that, FinCEN has encouraged people to, continue to voluntarily report, while this injunction's in place and while the status of the Corporate Transparency Act is in limbo.
Yeah, hey Evan, good to hear from you. I see your question in the chat around donor advised funds and secondaries. I wouldn't get too on this call. I wouldn't get too specific here. I think if you have an individual who wants to figure out how to do this, my suggestion would be two things. One, that they need to figure out how to do this, and two, they need to eat the cost of figuring out how to do it with their counsel. So this is not a problem that you need to solve. Obviously there might be something very specific about the circumstance where you want to kind of jump in and support here. But by and large, this is about how an LP wants to engage with one of their affiliated entities. And donor advised fund has their own set of regulations and laws. So that's going to be a transaction that's going to require some counsel. And I think it's up to that partner to do that homework themselves rather than expect the fund to do it. And, to the extent that there are legal costs that the fund would bear in support of this LP's transaction, that LP would pick the cost up on behalf of the partnership overall. So that's my view. I don't know if that's helpful or not, but that'd at least be a starting point.
Yeah, that's a very specific question, and I think your general guidance there, Nate, is good. And also referring to your own governing documents and what the LPA says about transfer expenses and who should bear them. But in this case, with the specific type of case, yeah, that's really based on the governing documents in your LPA and what the specific LP, the work they do on their own, and your ultimate decision of whether or not to grant that request based on your governing documents.
Cool. All right. Well, thanks everyone. Some contact information here for Eric and for Matt at Ross Law. We'd love to be able to learn more about you and your fund and the support that we could provide. We've enjoyed working with our clients this year as they have allocated more and more of their time to identifying investments as raising capital with the trust and the assurance that comes from the partnership they have with us, that we can continue to support them, support their portfolio companies, and help them build an enduring investment firm. Thank you all so much. Matt, thank you, and Gary for joining us for this presentation. Hope everyone has a great evening. Thank you.
Thank you, guys.